A woman in Mississauga has been living without heat for 11 days in January. The temperature inside her unit has dropped to 8 degrees Celsius. She has called her landlord 4 times. She has sent 3 text messages. The landlord's response, when it finally comes, is a single line: "We're working on it." She does not call a lawyer. She does not file a form. She wraps herself in blankets, runs the oven with the door open, and waits. Because nobody ever told her that what her landlord is doing is not just bad customer service. It is illegal, specifically, provably, actionably illegal. And she had the right to force a repair or to legally withhold rent starting on day 2. She did not know that. Her landlord did. That is not an accident. Hi, my name is Noah, and this is Maple Canada, the channel where we pull apart the systems, the products, and the institutions that Canadians trust with their money and their safety, and show you exactly what is hiding underneath the surface. Today, we are talking about your rental unit, about the legal obligations your landlord signed the moment they put their name on a tenancy agreement. Obligations most of them are counting on you never discovering. This video is going to be long. Stay with me, because what I'm about to show you is not general advice. This is specific, enforceable, documented law, and every minute you spent watching it is worth more than anything a paralegal would charge you to explain it. To understand how badly the system is failing you right now, you have to understand what it was designed to do. In the early 1970s, Canada's rental market was substantially unregulated. Landlords could raise rent by any amount, at any time, for any reason. They could enter a unit without notice. They could evict a tenant within days for complaining about conditions. The power imbalance was total and completely legal. Then provinces started building frameworks. Ontario passed the Landlord and Tenant Act in 1975. British Columbia followed. Alberta restructured its residential tenancy law multiple times through the 1980s. Quebec had its own regime under the Civil Code, widely regarded as the strongest tenant protections in the country. The intent was clear: create a minimum floor of rights below which no tenancy could fall, a standard of maintenance, a process for disputes, a mechanism for tenants to push back without losing their housing. For a while, the framework held. Landlord-tenant boards were under-resourced but functional. Hearing wait times were measured in weeks, not years. A tenant with a legitimate complaint had a realistic path to resolution. Then 2 things happened simultaneously, and they quietly dismantled everything. The rental housing supply collapsed. Canada stopped building affordable rental units at scale in the early 1990s. When the federal government eliminated tax incentives for purpose-built rental construction, the vacancy rate in Toronto, Vancouver, Calgary, cities where most Canadians actually live, dropped below 2%. In a functioning market, a tenant with a bad landlord can move. In a market where the vacancy rate is 1.3%, and the next available unit costs $400 more per month, you cannot move. You absorb whatever your landlord does to you, because the alternative is worse. And the Landlord and Tenant Board, Ontario's primary dispute resolution mechanism, collapsed under its own backlog. As of 2024, tenant applications were waiting an average of 8 to 12 months for a hearing. Landlord applications for non-payment moved faster. The asymmetry is not subtle. The system designed to protect tenants was restructured through funding decisions and staffing shortfalls into a system that processes landlord evictions. The rights did not disappear. They are still on the books. Every province has them. Most tenants simply have no idea they exist. Today, I'm going to walk you through exactly what your landlord is legally required to do and what happens when they don't. Let's start with the most fundamental obligation in Canadian residential tenancy law, because it is the one violated most often and the one tenants are least likely to know about. In Ontario, Section 20 of the Residential Tenancies Act, 2006, states that a landlord is responsible for providing and maintaining a residential complex, including the rental units in it, in a good state of repair and fit for habitation, and for complying with health, safety, housing, and maintenance standards. Let me say that again because I want it to land properly. Good state of repair, fit for habitation, compliance with health, safety, housing, and maintenance standards. This is not a suggestion. This is not a best practice guideline. It is a statutory obligation. It applies regardless of what your lease says. You can sign a lease that says the tenant is responsible for all repairs. That clause is unenforceable. The Act overrides it. A landlord cannot contract out of their maintenance obligation. Full stop. British Columbia's Residential Tenancy Act carries the same framework under Section 32. Alberta's Residential Tenancies Act contains it under Section 16. Saskatchewan, Manitoba, Nova Scotia, New Brunswick, every province has a version of this clause. What does good state of repair actually mean in practice? The courts and tribunals have been clear. It means heating systems must function. In Ontario, landlords must maintain a minimum indoor temperature of 21 degrees Celsius. From September 1st, 1st to June 15th. That is not a recommendation. It is a bylaw enforceable by municipal property standards inspectors. The woman in Mississauga I mentioned at the start of this video had the legal right to call the city on day 1. An inspector can be dispatched. A work order can be issued. In urgent cases, this happens within 24 to 48 hours. Plumbing must work. Hot and cold running water is not a luxury, it is a legal minimum. A landlord who allows a plumbing failure to persist, a broken hot water tank, a blocked drain, a failed toilet, is in breach of their maintenance obligation. From the moment they are notified and fail to act within a reasonable time frame, the structure must be weather-tight. Roof leaks, window failures, door gaps that allow cold air infiltration. These are not cosmetic issues. They are maintenance failures that trigger the landlord's legal obligation to repair. Appliances included in the lease must work. If your lease includes a fridge, a stove, or a dishwasher, and those appliances break, your landlord is obligated to repair or replace them. Not eventually, within a reasonable time frame. Tribunals have generally defined reasonable as days for essential appliances, not weeks. Pest infestations are the landlord's problem. This is the one that surprises people most. In Ontario, under Ontario Regulation 517-06, a landlord is responsible for exterminating insects, rodents, and other pests in the residential complex. You cannot be billed for it. You cannot be held responsible for an infestation in the building's common areas. Even for unit-specific infestations, the standard is complex, and the default responsibility falls on the landlord unless the tenant demonstrably caused the infestation through specific behavior. This one is violated more often than any other provision in Canadian tenancy law, and it is violated casually, routinely, by landlords who simply assume their tenants do not know. Your landlord cannot enter your unit without notice. In Ontario, the Residential Tenancies Act, Section 26 and 27, is explicit. A landlord may enter a rental unit only under specific circumstances, and in most cases, only after providing written notice at least 24 hours before the entry. The notice must specify the reason for entry and must specify a time of entry between 8 a.m. and 8 p.m. Written notice does not mean a text message that says coming by tomorrow. It means a written notice that states the date, the reason, and the time window. And even then, the window cannot be open-ended. Tribunals have found that notice saying sometime between 9 a.m. and 5 p.m. is insufficient. The exceptions are narrow. A landlord can enter without notice in cases of emergency, a fire, a flood, a gas leak. A landlord can enter without notice if the tenant consents at the time of entry. That's it. There is no exception for I'm the landlord, I own the property, or I just need to check something. A landlord who enters your unit without proper notice is committing what the Act calls an illegal entry. You can file a T2 application, tenant application about landlord's illegal actions, with the Landlord and Tenant Board. If the board agrees the entry was unlawful, it can order the landlord to pay you up to $25,000 in damages. $25,000 for walking into your apartment without 24 hours written notice. Your landlord knows this number, or they should. Most of them are betting you don't. British Columbia's framework is identical in substance. Section 29 of the BC Residential Tenancy Act. Alberta requires 24 hours notice under Section 23 of the Residential Tenancies Act. The standard is provincial, but the principle is national. Let me tell you about the rent increase guideline, because this is where the gap between what landlords are allowed to do and what tenants believe they can do is widest. In Ontario, landlords who are subject to rent control, and we will get to who is exempt in a moment, can only raise rent once per year, and only by the provincially set annual rent increase guideline. For 2024, that guideline was 2.5%. For 2025, it was 2.5% again. That percentage is the ceiling, not a suggestion, a legal ceiling. A landlord cannot raise your rent by more than the guideline amount without applying to the Landlord and Tenant Board for an above-guideline increase, an AGI, and proving specific, documented grounds. What qualifies for an AGI? Extraordinary increases in municipal taxes or charges, capital expenditures, major building improvements that meet specific criteria, not cosmetic renovations, not a fresh coat of paint in the lobby, documented capital work, proven to the board. Here is what your landlord also cannot do. Raise your rent mid-lease. A rent increase is only valid if the landlord has provided at least 90 days written notice. 90 days, not 60, not 30, on the proper form. In Ontario, that is Form N1. A rent increase notice on a piece of paper, in an email, or in a text message is not valid. The form matters. And here is the provision most tenants have never heard. You can refuse an illegal rent increase. If your landlord raises your rent without proper notice on the wrong form, with less than 90 days notice, or by more than the guideline, you do not have to pay it. You continue paying your existing rent. The illegal increase is void. If your landlord tries to use that unpaid increase as grounds for eviction, the board will reject the application. Now, the exemption. This is important, and this is where the system broke. In 2018, the Ontario government under Doug Ford exempted all residential units first occupied for residential purposes after November 15, 2018 from rent control. This includes the majority of new condo buildings and apartment towers built in the last 6 years. If you moved into a newer building, you may have no rent control protection at all. Your landlord can raise your rent to any amount with 90 days written notice without any guideline restriction. This is the single largest erosion of tenant protection in Ontario history, and the majority of the tenants living in these buildings do not know it applies to them. Check your building's first occupancy date. If it is after November 15, 2018, you need to know that the guideline does not protect you. When you moved in, your landlord almost certainly collected a last month's rent deposit, 1 full month's rent, held by the landlord, to be applied to your final month in the unit. What almost no tenant knows is that this deposit earns interest every year. In Ontario, under Section 106 of the Residential Tenancies Act, the landlord must pay interest on the last month's rent deposit equal to the rent increase guideline for that year. They must pay it annually. It accumulates. If you have been in your unit for 5 years, your landlord owes you 5 years of accumulated interest on your deposit. If the deposit was $1,800 and the guideline averaged 2% per year, your landlord currently owes you somewhere in the range of $180 to $200 in accumulated interest. They can pay it to you directly, or they can apply it against a future rent increase. Most landlords do neither. They simply hold the deposit and never acknowledge the interest obligation. You are entitled to it. You can demand it, and if your landlord refuses, you can file a T1 application with the board, a claim for money you are owed, and the board will order it paid, potentially with additional remedies for the landlord's failure to comply. We have covered the positive obligations, what landlords must do. Now let me walk you through the prohibitions, the actions that are flatly illegal regardless of what your lease says, regardless of what your landlord tells you, regardless of how the conversation goes. Changing the locks. A landlord cannot change the locks on your unit without your consent and without providing you a new key immediately. A landlord who locks you out of your home without a sheriff-enforced eviction order is committing an illegal lockout, a serious breach of the act. You can call the police. In Ontario, you can file an emergency T2 application and receive an urgent hearing. The board can order your immediate re-entry and can impose financial penalties on the landlord. Removing or interfering with vital services. A landlord cannot cut off your electricity, heat, hot water, or other vital services, even if you owe rent, even if you are in a dispute, even if the landlord is attempting to pressure you to leave. Interfering with vital services is illegal under the Act and constitutes what is sometimes called a constructive eviction, an attempt to make the unit uninhabitable in order to force departure without following the legal eviction process. The penalties are significant. Harassment and interference. Under Section 23 of the Ontario Act, a landlord or a person acting on behalf of a landlord shall not harass, obstruct, coerce, threaten, or interfere with a tenant. This includes showing up at the unit unannounced and repeatedly. It includes sending threatening communications. It includes interfering with the tenant's reasonable enjoyment of the unit. Documented harassment is grounds for a T2 application and for financial remedy. Discriminatory practices. Under the Ontario Human Rights Code, which operates above and alongside the Residential Tenancies Act, a landlord cannot refuse to rent to you or discriminate in the terms of your tenancy on the basis of race, ancestry, place of origin, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity or expression, age, marital status, family status, disability, or the receipt of public assistance. A landlord who refuses to rent to a family with children, no kids, is violating the Human Rights Code. A landlord who refuses to rent to someone on housing assistance, Ontario Works ODSP, may be violating the code depending on the circumstances and the province. The renoviction. This one has been in the news, and for good reason. A renoviction is when a landlord issues an N13 notice to terminate tenancy for demolition, repairs, or conversion, as a pretext to remove a long-term tenant and re-rent the unit at market rate. The law has specific protections against bad faith N13 notices. The tenant has the right to return to the unit after renovation at the original rent. The landlord must pay compensation during the displacement period, and if the landlord does not actually complete the renovations or re-rents the unit without allowing the tenant to return, the tenant can bring a bad faith application, and the board can order the landlord to pay up to 12 months' rent as a penalty. The eviction process in Canada has procedural steps that are non-negotiable. A landlord cannot evict you informally. They cannot tell you verbally that you need to leave. They cannot post a handwritten note on your door and consider the matter settled. The legal eviction process in Ontario flows through a specific sequence. The landlord serves a written notice, an N form, that specifies the reason for termination and the termination date. Different reasons have different notice periods. Non-payment of rent generates an N4, 14 days notice, with a 14-day window for the tenant to pay pay and void the notice. Persistent late payment generates an innate 60 days notice. Even for unit-specific infestations, the standard is complex and the default responsibility falls on the landlord unless the tenant demonstrably caused the infestation through specific behavior. If the tenant does not vacate by the termination date and does not resolve the issue within any applicable voiding period, the landlord must then file an L application with the Landlord and Tenant Board. This generates a hearing. The tenant will receive notice of the hearing and has the right to attend and present their case. If the board rules in favor of the landlord, it issues an eviction order. That order specifies a date by which the tenant must vacate. If the tenant does not vacate on that date, the landlord must request enforcement of the order through the sheriff's office, the court enforcement office. Only a sheriff can physically execute an eviction. The landlord cannot move your belongings. The landlord cannot change the locks at that point without sheriff involvement. At no point in this process can your landlord skip a step. A landlord who physically removes a tenant before completing all of these steps, every single one, is committing an illegal eviction. The consequences are severe and documented. You have the right to hold them to the law, every single step. If you have watched this video and you are living in a situation where your landlord is not maintaining your unit, is entering without notice, is harassing you, or is attempting an illegal rent increase or illegal eviction, here is exactly what you do. Document everything. Start today. Photograph every maintenance issue. Screenshot every text message. Write down every verbal interaction with date, time, and summary. If your landlord enters without notice, write it down immediately. Date, time, approximate duration, what they did inside. Documentation is the foundation of every successful tenant application. Send written notice. For maintenance issues, send your landlord a written request, text, email, or letter, specifying the problem and requesting repair within a reasonable time frame. Keep the record. This notice is what establishes the landlord's awareness of the problem, which is what the board will ask about. Know your forms. In Ontario, T1 for money owed to you, including interest on deposit. T2 for illegal acts, illegal entry, harassment, withholding vital services, illegal eviction. T6 for maintenance issues. These forms are available free on the Landlord and Tenant Board website. Contact your local community legal clinic. Every region of Ontario has a community legal clinic that provides free legal assistance to low and moderate income tenants. They will help you file your application, prepare for your hearing, and understand your rights. They exist specifically because the Landlord and Tenant Board is difficult to navigate without help. Call 311 for emergency maintenance. Municipal property standards inspectors have authority to act on heating failures, structural hazards, and other urgent maintenance issues independently of the LTB process. In many cases, this is faster. In British Columbia, the equivalent is the Residential Tenancy Branch, rtb.gov.bc.ca. In Alberta, it is the Residential Tenancy Dispute Resolution Service, RTDRS. Every province has an equivalent body. The process is not quick. The systems are not well funded. The wait times are real, and they are a problem. But the rights are real. The remedies are real. And the gap between what your landlord owes you and what they believe they can get away with is wide enough to drive through, if you know it exists. The woman in Mississauga who spent 11 days without heat, she eventually called the city. A property standards inspector issued a work order within 48 hours. The heat was restored within the week. She did not get compensation for the 11 days because she did not file a T2 application. She did not know she could. She knows now, so do you. If this video helped you understand something your landlord hoped you would never find out, share it. Send it to someone renting right now. The gap between what the law says and what landlords do is not technical complexity. It is information control. That gap closes one person at a time. My name is Noah. This is Maple, Canada. See you in the next one.